Thank you for joining us for the second webinar in our special asset summer school series. If you missed the first webinar, it does live on our website under the webinars tab. Please chat me and I'm happy to get you that link. But if you did miss the first one, we'd love to still have you look at that content. You won't miss, you won't be left out on this presentation, I promise, but I do want to make sure you know you have accessibility to that. If you have any issues with video or sound quality during this presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers today, Lance and Paul, are going to be happy to take questions during this webinar. If you have a question, please type it into the Q&A box and it will be addressed at the conclusion of the presentation. All right, Lance, I'm going to turn it over to you.
Thank you, Haley. And welcome everyone. My name is Lance Martin and I'm joined today by Paul Fanning. Paul and I have been practicing together at Ward & Smith for just under 25 years. And most of that time has been on the, with a full service bankruptcy practice, primarily representing secured lenders in the commercial space. And so we welcome you. Many of you are friends and clients, but there's also a lot of new people. So we thank you for taking the time, and we hope that you will find today's presentation meaningful. Before we get into the meat of the presentation, Paul, did you have anything you wanted to add before we get started?
No, I wanted to thank everybody for coming. I went through the list of attendees and it's really a distinguished list. As you said, a lot of friends, a lot of people we have represented for a long time, and a lot of people that we haven't heard from for a long time. There haven't been that many bankruptcy cases filed in the last few years, but we're seeing a trend upward. So we look forward to getting to know you. Couple of shouts out. Number one is to Lance. Lance is a real expert. He's a board certified specialist in bankruptcy. And certainly in the Western District of North Carolina, he is looked upon as one of the go-to professionals there, not only from the attorneys, but from the judges as well. So he really knows what he's doing. I noticed on the list that my old bankruptcy professor from Wake Forest University School of Law, Steve Nichols, with whom I keep in touch, is also looking on, and appreciate that. So appreciate you all joining, and we look forward to the program.
Let's hope this seminar isn't graded. Paul and I got by in law school on gentleman C's. Just to give you an overview of what we're going to try to cover in today's webinar, sort of three topics. One, we're going to spend a few minutes just kind of giving you the lay of the land on what's going on in the world of bankruptcy at the macro level. I attended a seminar for the American Bankruptcy Institute last week, and they shared some slides. So I'm going to share some of those slides with you and just kind of give you just a thumbnail sketch, 5 or 10 minutes of what's happening nationally and what Paul and I are seeing both in the eastern, middle, and western part of the states. From there, we're going to delve into two substantive areas, one of which is litigation funding in bankruptcy. Very interesting, very controversial topic that has come to North Carolina, and Paul has been heavily involved in that. So he'll talk to you about litigation funding, what it is, and what it means for you as a commercial lender in bankruptcy. And then we're going to finish up with dealing with fraudsters in bankruptcy. We in late February, we got a decision on fraud, discharge, and bankruptcy from the United States Supreme Court. And the United States Supreme Court doesn't take many bankruptcy cases. So when they do, and when they issue an opinion, we always give it a lot of attention. And this one could have profound implications for you as secured lenders, particularly working out in workout situations and litigation. And so we'll get into that as well. So we'll start with the trends, then litigation funding, then we'll deal with fraudsters and bankruptcy and the discharge of debts. And I'll kick things off with the filing trends. And Haley, if you want to put up the first slide, please. So this is just kind of a historical snapshot of total bankruptcy cases. So you can see kind of where we've been and where we're going. You will see 2009, 2010, 2011. That was sort of that was the Charles Dickens Great Recession time period. If you're a special assets officer or a bankruptcy attorney, it was the best of times, it was the worst of times. And there's been sort of a slide since that time, and as the economy sort of roared back up to the pandemic and in the pandemic. And you will see, 2020, 2021, 2022, historically low levels of bankruptcy. So when we talk about an increase in bankruptcy, we are seeing an uptick in bankruptcy. It is an uptick from historically low levels. Next slide, Haley. Okay, and so here you will see, so here's trends from 2010 forward. So quarter change, I'm getting hidden here, sort of quarter by quarter change. So you will see we went way below in the pandemic with PPP money and deferrals and everything else. Nobody needed to or was filing bankruptcy for the most part. And you can see that we're starting to get an uptick in 2022, the last 2 quarters, and the first 2 quarters of 2023 against the norm, about 15 to 18%. Next slide, Haley. Okay, and so here you see all chapters, year to date, 2023 versus 2022, 17.3% increase down there. North Carolina is above the average at just under 23%. Next slide, Haley. Okay, and here's commercial filings. You will see commercial filings remain far below the monthly historical average. Next slide, Haley. So this is all chapter 11, are all chapters, commercial cases. So this is going to be primarily chapter 11 cases. Again, 18% increase. North Carolina, in the top 15 there, along with some other southeastern states like Georgia and Tennessee. Next slide. These are subchapter 5 cases. And by the way, if anybody wants to see these slides in more detail, we'll be happy to share them with you along with the entire PowerPoint after this presentation. I can email them to you. Subchapter 5, as you may recall, is the small business sort of fast pass bankruptcy for debtors who have under $7.5 million in commercial debt. It's an extremely popular form of reorganization for debtors who qualify for it. And as you can see, that number, first half of 2023 compared to first half of 2022, is up 54%. And I think I might have 1 or 2 more slides. Okay, and then yes, I just wanted to finish with this one. This is chapter 7 cases. So getting away from commercial, there's chapter 7 primarily individual, some commercial, sort of tossing the keys in commercial filings, but you can see post-pandemic how we were well below average, but in the first 2 quarters of this year, we are starting to see an increase in Chapter 7 individual filings. What is causing these trends? You probably know more than us. Paul and I aren't economists. At the ABI webinar, they were saying that there's real pressure in certain sectors, the rural healthcare infrastructure, rural hospitals, and rural medical practices are suffering for a variety of reasons. And then, as I'm sure you all reading, commercial real estate in urban areas and cities are really struggling coming out of the pandemic with work from home and other issues. We are seeing, certainly in the Western District, we're seeing a lot of failure in the last year. Some of it isn't even making it into bankruptcy, and it's for a variety of reasons. But we're seeing a significant number of restaurant failures and brewery failures for the first time in a long time. It seemed like we only saw reports of breweries opening, not closing, but we're getting a lot of brewery failures in Western North Carolina, restaurant failures. We had an apparel company that was selling high-end outdoor clothing that shut its doors recently. We're involved in a basalt fiber manufacturing company that didn't feel like it could reorganize, and it went into receivership rather than filing Chapter 7. We've got another manufacturer in, like they basically make big vats of shampoo and other types of hair products, been around since 1973. They just filed a subchapter 5 case. And then we've got the sort of the old reliables of massive fraud cases, whether it be Ponzi schemes or sort of shell game, selling collateral out of trust and other things. And I don't know what it is about North Carolina, but it seems like those cases pop up annually or biannually. And we've had several in 2023 with some sticker shock in terms of the losses to the creditor class. Paul, do you have any insights on filings in other parts of the state?
Yeah, so pretty much what you said, we're seeing in the east and the middle of the state as well. In addition to that, a lot of trucking industry bankruptcies, also farming bankruptcies, a lot of agricultural land in the eastern part of the state. The price of inputs is very high right now, and that's pressing on farmers. So we're seeing a lot of those as well, and we certainly have our fair share of fraud. That is what really makes our job interesting, kind of unraveling the fraud, trying to determine the best method by which to recover from the fraud, and a lot of those end up in bankruptcy eventually.
And we will circle back to that fraud issue in the third part of the seminar. But now I've talked for long enough, and I'm going to turn it over to Paul, who's going to talk about litigation funding.
Right. Yeah, litigation funding is a new concept, really, in North Carolina. You read in the Wall Street Journal, other periodicals about litigation funding on a huge scale, and it's a really big business. Litigation funding takes place outside of bankruptcy frequently and outside of North Carolina. As Lance mentioned, I happened to be involved in a case which we believe is the first case in a North Carolina bankruptcy court to approve a litigation funding model. North Carolina is unique. They have laws on the books in cases going back a very long time, which prohibit champerty. What is champerty? I had to look that up and get a good definition. It's an agreement in which a person with no previous interest in a lawsuit finances it with the view to sharing the recovery if the suit succeeds. And so in North Carolina, which is different from Delaware or New York or Texas, where you have these big bankruptcy cases. In North Carolina, it's really against public policy and has been for a very long time. Very recently, in fact, last month, Judge Callaway in the Eastern District approved a litigation funding model, and we all had to learn in that case, and it was very interesting, and there's a lot of thought and deliberation and due diligence that goes into the analysis. So what exactly is litigation funding? It's a mechanism or a process through which litigants can file their litigation or other legal costs through, finance through third-party funding, kind of like a bank. They go out, they've got a lawsuit, they've got a claim against somebody, but they don't have the money to fund it. As you might be aware, litigation is very expensive. Hiring lawyers that charge by the hour, even though our hourly rate is so much lower than most.
Yeah, I would just say totally worth it. Even if it's expensive, totally worth it.
Good, totally worth it. It gets expensive, and when we're talking about bankruptcy, we're talking about bankruptcy estates. We're talking about bankruptcy trustees. If it's a super good case, you might get a law firm that will come in and handle the case on a contingency basis, purely. But there's a significant amount of risk associated with taking on a contingency case. And so, sometimes that's just not available. We've all heard about legal defense funds. This is very similar. Legal financing companies, though, provide money for lawsuits, but they're more often used when there's no strong financial resources as a backing. Why is it relevant? Why do you care? Well, you may be on one side of a lawsuit or another. You may be a creditor in a bankruptcy case, and you're looking for a recovery. You're interested in the end result. You want the litigation to go forward. You may be the beneficiary of a successful result. And so you may need to know a little bit about it in order to support it, make sure it gets approved and implemented. You may be on the other side of a lawsuit. You may be a defendant against a bankruptcy trustee. And if you are, you're a bank, you've got plenty of money, and you can outlast a bankruptcy trustee, which is exactly the situation that I was talking about. We at least in one particular lawsuit, we have a deep-pocketed, very wealthy individual on the other end. And their strategy is to simply outspend the trustee. So in that particular case, it became necessary for the trustee to look for options to fund the litigation. And so it is useful for to know the reasons why a bankruptcy court might approve this scenario or why it might not. What is a litigation funder? Well, kind of like a bank. We're mostly talking about private equity or investment firms. Litigation funders is a very specialized niche or industry. The group that we were, there were several groups that we were vetting in kind of a beauty contest, but lots of lawyers, lots of bean counters. They knew what they're doing, very smart people. It could also be, you know, an interested party in a bankruptcy case. So first off, what do these litigation funders look at to decide whether to fund? Well, you know, they need to know a lot about the litigation. They need to really understand it. They need to understand the amount of money that it's going to take to fund it through not only trial, but also through appeal and through post-judgment procedures, recovery, you know, judgment, execution, that sort of thing. They need to understand, because the last thing a funder wants to do is come in and fund and get to a certain point in the litigation, and then there's no more money to fund it through to the end. That's a disaster and a big loss. They need to understand the issues in the litigation. I mean, they really dig into the pleadings. They dig into the professionals that are on both sides. They dig into the likelihood of success on the merits in the case. They want to know who the judges are. They want to know if there's going to be a jury or not a jury. They want to know, you know, what's the jury pool look like. So they really dig into that. They also, perhaps the most important piece is the professionals that they're dealing with. Who is on their team? Who is the attorney or set of attorneys or law firms that will be handling it? Those professionals are in it as well, and it needs to be a team approach. They also need to share in the risk and have the incentive or motivation to get to the end result that everybody wants. They also look not only at the likelihood of success on the merits in the lawsuit, but also the likelihood of collection and recovery. And this hits at the heart of what you guys do every day. They look at the public record. They look at industries. They look at credit reports, Accurance, Westlaw, Lexis. They hire private investigators, and they look at local reputation. They want to know that if they're investing in a case, that there's going to be a pot of gold at the end of the rainbow. And obviously, all of this carries a huge amount of risk. You're investing a significant amount of money into a lawsuit with a process that is simply uncertain and an outcome that is uncertain. So they have to go through their own underwriting considerations, much like you all do every day. They need to manage the risk of the return and the reward. They need a reward for that risk. So they're looking for their return on investment. They're going to utilize an interest component, sometimes compounded. They look for success fees, uplift fees, or multipliers in order to, take advantage of the upside in the event that what they hope will happen actually happens, and they get paid for it. Very creative indeed, is what I have seen. And they're all taking a super priority priming lean on any and all recoveries out of litigation. They get paid first. Rarely do you see them sharing their recovery with other creditors. So that's what they're looking at. The next piece is, what does a bankruptcy court look at in order to decide whether to approve these? I guess the first foregone conclusion is these things have to be approved by a bankruptcy court. The bankruptcy court must see that there is no other favorable financing that was sought and just not available in the marketplace. In other words, just like I talked about before, you know, if it is available to do it on a contingency fee, 1/3 or even half, if that's not available, if it is available, then the trustee should probably take it in order to get a better deal for the creditors at the end of the day. Proponents of funding must prove that this is in the best interest of all creditors of the bankruptcy estate. And that the likelihood of success, and at the end of the day, when all the dust settles, there will be a higher return to creditors than if this funding arrangement was not entered into. The trustee gets the benefit, but has to show that it's exercising sound, reasonable business judgment. Very importantly, the trustee must control all aspects of the litigation. The funder cannot have control over the litigation. The funder wants control over the litigation. The funder thinks that it is in the best position to control the litigation. But in order for a bankruptcy court to approve these, in most instances, the trustee must remain in control of all aspects. That means who they can hire as a professional, who they can hire as an expert witness, other aspects of the litigation, strategy, whether to settle, whether not to settle, and for how much. The court also needs to understand the recovery payment waterfall. Where is all the money going? These funding arrangements get very complicated in terms of where the money goes. It's not always cut and dry. And the court has to understand that in order to approve it. Typically, the funding companies are only paid through proceeds from the litigation, not from general assets of the estate or from collateral of other creditors. Ultimately, the funder liens or the claims must be fair, reasonable, and adequate under the circumstances. And I've seen, at least in our case, where the court retained jurisdiction to make sure that professional fees are reasonable at the end of the day. We had a case that came out a few years ago in the Western District in Charlotte, where litigation funding was denied. It was denied because it was conditioned on the constant review and approval by the funder of the strategy and the budgeting. And so the court in that case denied funding because the funder would be in control of the litigation. And that goes against the principles in North Carolina. So that in a nutshell is litigation funding in bankruptcy cases.
Thanks, Paul. Yeah, I mean, this is litigation funding. It's fascinating. If a case goes into Chapter 7, whether the debtor does so voluntarily, or the creditors team up and file an involuntary, or a Chapter 11 case is converted, you get a trustee, and that trustee has a fiduciary duty to, pursue all avoidance and other actions available to him or her for the benefit of the creditor class. But he or she's not required by the court to work for free or to retain attorneys who will work for free. So there's a tension there when there's a claim against someone between trying to get a recovery, trying to maximize a recovery, but figuring out how you're going to pay for it. Litigation funding is one new to North Carolina potential tool available. Like Paul said, they're very complicated, and they are gonna, they try to structure these deals where to kind of reduce their risk or hedge their risk, and get paid as much as they can off the top up front. But if you find yourself in a situation here where you're probably at this point, you have an unsecured claim, your secured collateral has been sold and the proceeds have been remitted to you. You've got an unsecured claim, but it's important to you to try to get some recovery on that. Then you probably have you will have an opportunity, since the court has to approve it, to weigh in on the terms of any deal, so that in this waterfall, there is going to be some recovery for creditors, that it's not structured such that only the attorneys and the litigation funder are going to get paid. So there are pressure points in there where you may be able to either negotiate better terms or try to convince the court to get better terms. And then if you find yourself in a case where the trustee just wants to abandon a claim that you think has some merit, then maybe this is the opportunity to have your counsel talk to the trustee and his counsel, and as they say on these pharmaceutical commercials, see if litigation funding is right for you. So maybe that's a possibility there. But I don't think the case that Paul's been working on is the last word on litigation funding. It seems to be trending in a more accepted or posture nationwide, and we'll just have to wait and see if the courts in the Middle District rule on this, or whether Judge Whitley or Judge Beyer in the Western District revisit their decision where they declined to allow funding. It's going to be fact sensitive, as Paul pointed out.
Yeah, Lance, if I may, we had a good question come in, and that is, can a creditor in a bankruptcy case be approved as a funder? And the answer is yes. Under the same guidelines, just because you would be a beneficiary of a recovery at the end of the day does not prevent a creditor from being the funder. The terms can be just as favorable to a creditor if they stand in the shoes of a funder. There's no prohibition, no conflict of interest. And there are several cases that we reviewed which say that. So great question, and something to keep in mind going forward.
All right. Thank you, Paul. We will transition now to fraud. And I want to talk about the United States Supreme Court's decision from March. It was called Bartenwerfer. And this was a unanimous decision by the United States Supreme Court, in a time of polarization on the court and elsewhere. This is like it all come together. All of the justices came together and agreed on this. So as I'm sure many of you know, individuals can file bankruptcy to get their fresh start in life and discharge their debts. And what we say in the bankruptcy world is that the bankruptcy code is for the honest but unfortunate debtor. It is not a sanctuary for a dishonest debtor. So the bankruptcy code has a variety of exceptions to discharge, exceptions to your fresh start. And some of those exceptions are fraud, embezzlement, larceny, fraudulent representations, either in writing or orally, defalcation in a fiduciary capacity. That's a situation where you've got a fiduciary relationship, like your, I'll give you an example, like your closing attorney at a real estate, and the closing attorney, instead of dispersing closing proceeds, steals the money. We've got a big case pending in the Western District of North Carolina, the Eastern District of North Carolina right now, involving a law firm that had operations in the western part of the state and in the Wilmington area, and they were using their trust account for real estate closings as sort of a personal ATM. Those lawyers are not going to be discharged in bankruptcy. You could be sure of that, for the money they stole. So that's the background. So in the Barton-Werfer case, you had a couple living in San Francisco. They were unmarried, and they bought a house. They were going to do a house flip. So they bought the house together. They renovated the house. The husband, David, did most of the work. So he hired the contractors, he supervised, he paid invoices. His girlfriend at the time, Kate, she left him to it. And according to the Supreme Court, she was sort of passive, not involved. Eventually, they sell the house to a buyer, and the buyer discovers, when he takes possession, that there were several undisclosed problems and defects with the house. There was a leaky roof. It was supposed to have a fire escape. It didn't. There were all sorts of permitting problems. Buyer sues Kate and David. He gets a judgment against both of them for non-disclosure of material facts, breach of contract, etc. They can't pay the judgment. They both file bankruptcy. Okay, they both file Chapter 7. The bankruptcy court holds that as to David, it's not even a question. It's a slam dunk. This debt's not going to be dischargeable. This is money he got at the closing as a result of non-disclosure of material facts. That falls under the category of false misrepresentation, fraud. He's stuck. He might be able to discharge his other debts, but this one he's on the hook for. No discharge for him. The bigger question was, well, what about Kate, who was largely uninvolved and did not engage in any active acts of concealment or misrepresentation? Court said she doesn't get a discharge either. They said that despite her lack of any fraudulent intent, because they were in a partnership together, where they were in the business, they were partners, they were flipping this house, they both owned it, that under state partnership law, if you've got a partnership, you can impute liability from one partner, the bad actor partner, to the quote unquote innocent partner. And for that reason, the Supreme Court said that Kate, even though she may have been an innocent, unaware, uninvolved partner, she was still liable for the debt, and she could not get it discharged in bankruptcy. Big ruling, very creditor friendly. So this is a case that we are going to be thinking about. It's like the Carmel. What do you do? It's like the Carmela Soprano problem. Like what do you do with Carmela Soprano? If your borrower is Tony, it's easy. You've got a debt to the business. Tony's the guarantor. You've probably got contractual remedies against him. But if he's a fraudster or a bad actor, what remedies, if any, do you have against a spouse, or maybe an adult child who may be benefiting from the fraudulent conduct of your borrower or guarantor. So outside of bankruptcy, you've got a variety of common law weapons at your disposal. You know, we've got the Voidable Transfer Act for fraudulent transfer of, you know, ill-gotten gains to a spouse, family member, another partner, official or unofficial, claims of unjust enrichment, restitution. You know, equity allows you to impose a constructive trust, you know. So if Tony Soprano is stealing money from you and that money is flowing to his wife and kids in the form of fancy cars, jewelry, you know, homes, other toys, you've got common law remedies to try to claw that back. But what if they file bankruptcy? So then if they file bankruptcy, that is when you have to determine whether or not you've got claims against them that would not be dischargeable. And just having a common law claim of unjust enrichment, where they shouldn't have got the money, is historically would not be enough. But I think with this Barton Werford decision, there is the potential there that you could have the debt non-discharged. So I think like one of the ways you could use it is certainly as leverage in negotiating with an individual before they file bankruptcy and forecasting that bankruptcy may not be the safe haven that they think it is, and that may keep you out of bankruptcy. It may result in a settlement, etc. It's an interesting decision. There was a concurrence that said, tried to limit its holding to specific instances where the so-called innocent person was actually a partner or an agent of the bad actor. So in all of these cases, it's going to be fact intensive on exactly what the fraud was and what happened, and what the relationship between the innocent party and the bad actor. There was a decision in Virginia, which is part of the Fourth Circuit, which oversees North Carolina bankruptcy courts, just about 10 days ago. And in that case, the court allowed a discharge in a fraud case of an individual that the court said basically he was a poor schlub who was an unwitting accomplice, and they could not find on the factual record for them any evidence that he was a partner in the fraud or an agent of the fraudster. There was no familial relationship, no marital relationship, no anything. He was just, some documents were put in front of him. He seemed to have some impairment issues as well. And for that reason, they said he could not, he was entitled to a discharge, even though he had a part in a fraudulent scheme. So again, it's going to depend on the particular fact pattern. But I think the takeaway is that a potentially powerful tool for use in pre-bankruptcy litigation and negotiation of a resolution, or if someone goes into bankruptcy, a possible opportunity to file an adversary proceeding to deny their discharge. And that takes us right to 12:45, which I think, Haley, was when we were gonna open it up to questions.
Yes, thank you guys. Please submit your questions in the Q&A. at the bottom or wherever the bar is on your screen. We'll be happy to get to those. We haven't had any come through yet. I'll give everyone a second. All right, so we do have one. I believe this is going to be for Paul. How can litigation for these matters be funded?
Yeah, so litigation for just any old litigation can be funded by anyone. It has to be approved by the bankruptcy court. It can be a bank, it can be a creditor, it can be a third party funding company. And so as long as you go through the process the right way and get approved by the bankruptcy court, you can be a litigation funder.
Yeah, and I mean, I guess the other point in that is that you have to remember when the bankruptcy is filed, as you know, the automatic stay goes into effect. And so you may have a claim against a third party, but if the debtor has a claim as well, the same claim, then the trustee, it's called the first crack rule. The trustee kind of gets the first crack at going after that third party. The principle being you don't want to have 10 creditors going after the same pot of recovery, benefit of the creditor class. You want a single forum. So, so it's the trustee's claim to bring, and he or she needs to decide if they can bring it, how they're going to pay for it, how they're going to fund the litigation. If they can't, they think it's viable, then you usually have an opportunity through your counsel to push the trustee to abandon the claim. And then maybe you can pursue it outside of bankruptcy. If it's no longer a claim that's part of the property of the estate protected by the automatic stay, then it's free game for other parties.
Great, thank you guys. We had another question come in from Vincent. Paul or Lance, are y'all able to see that in the Q&A? Y'all might be better to read it aloud than myself.
So the question is, does a guarantor of an entity that commits fraud bear liability, or better said, is the guarantor eligible to have its debt discharged? So, obviously entities act through individuals. And if the individuals engage in fraudulent conduct and they file bankruptcy, then any debts procured through fraud are not going to be discharged, whether or not they're a guarantor. If they are a participant in the fraud, then, and you can establish that, they're not going to be entitled to a discharge of that debt. And then if it's a partnership, you can impute bad acts to any of the other partners under North Carolina state law. There was a Supreme Court decision just a year ago on this. So the odds are that the other partners would not be entitled to a discharge of this debt. They filed bankruptcy through the doctrine of imputed knowledge. And it's depending on the size of a corporation or an LLC, the same principles may apply as to other members. It's kind of a sliding scale. The more he or she is involved in a potentially fraudulent scheme by the entity, then the greater the likelihood that they're not going to be entitled to a discharge based on their actions. But even if they're silent partner or not necessarily involved, if there's, according to the Supreme Court, if there's a partnership relationship or a principal agency relationship, and the term, I say the term partner, but it would extend into corporations or LLCs or other type of entities. There is the potential there that they too would not be entitled to a discharge under this new decision. Paul, do you have anything to add there?
No, but a guarantor, just by virtue of being a guarantor, would not necessarily be impugned with the same kind of bad conduct. So that's the only thing I would add.
That's right. Yeah, particularly if they're just if they signed on as a guarantor for some obligation, but they have no involvement at all in the operations of the borrower. Yeah.
Great. Well, we have time for one more. Either one of you can answer this, I suppose. Can creditors be approved as funders?
Yeah, actually, we got that one during my presentation, and absolutely they can. And you know, frankly, they may have the most incentive to have a favorable recovery in a bankruptcy case, and may be willing to fund litigation even if it's brought by a bankruptcy trustee, with the hope that, you know, the recovery is there and it enhances their individual or company recovery at the end of the day. So something to think about, something to consider, something to ask your counsel about.
Great. Well, if there's no more questions, I can go ahead and close this out. I'd like to thank Lance and Paul for your time today. Such a really valuable insight. For those of you in attendance, following this webinar, you will be sent an email with a recording of the session. This might come tomorrow in the morning, as it takes a little bit for us to get that uploaded to our system. But please save the date for our final installment of this series on August 16th. That will have Lance and Paul's colleagues Norman and Lily on their webinar, and will be receiving an email to register for that event shortly, if not tomorrow, in that email. We really appreciate you taking the time to join us, and hope you're able to take some information you learned today and apply it to your own business. Lance and Paul, anything else?
I would just say that you will not be sent a short survey. But if you want to send a review to Paul or me, please do so through the email. Thank y'all. In all seriousness, thank you for taking the time. We do appreciate sharing some time with you. We wish we could do it in person, but this is certainly a convenient way just to give you a little bit of insight of what's going on. We hope everybody enjoys the rest of the summer, and you know, we look forward to seeing you and working with you in the coming months and years.
Great. Thank you, guys. Well, that is going to conclude today's webinar, and I hope you have a great rest of your day. Thanks so much. Bye, everyone.